responsibilities of a personal administrator in a probate. Now, sometimes this person could be known as an executor. It can also be known as a personal representative. And in the probate process, this can be very overwhelming, but it's also very important. So today we're going to focus on one of the most sensitive and legally significant aspects of this role: handling payments of bills during the probate process. My name is Leon Jones Jr. I've been practicing law in courts in Arkansas for over 15 years in both corporate and government. But now I'm serving as the managing attorney here at Big Rock Legacy Law Group, where we help our clients with estate planning, business law, family law, and litigation. When someone passes away, the process that they use in Arkansas is called probate to transfer assets, to pay debts, and to make sure their heirs receive the inheritance according to the law. It's also a place that has tremendous responsibility on the personal administrator. So you become one who makes sure that the bills are addressed properly. Not too soon, not too late, but in the right order. It's not just a matter of bookkeeping, it's a matter of law. Paying the wrong bills first or failing to follow Arkansas rules can open up the estate to lawsuits and even expose the personal administrator to liability. So we're going to explore: 1, which bills must be paid and why; 2, which bills should not be paid and why; 3, the legal framework that governs decisions in Arkansas; and 4, the practical advice and special circumstances like insolvency. So by the end of this video, my goal is that you will have a clear understanding of the responsibilities of a personal administrator here in Arkansas and some steps that are needed to fulfill those responsibilities with confidence. So let's begin with the bills that must be paid, the ones Arkansas law prioritizes and requires for the administration of an estate. Funeral expenses under Arkansas law receive the highest priority. The reason is obvious. Honoring the deceased is not only a matter of respect, but also a legal requirement. So these expenses should be paid promptly, but reasonably. The law does not require extravagant expenditures. So while a dignified burial or cremation is covered, the administrator should be cautious about excessive costs that could be challenged later. For an example, if an estate only has $10,000 in assets, and the family decides to hold a $15,000 funeral, personal administrator may not be able to justify paying all of that cost out of the estate. Administrative expenses in this process have cost as well, and these include the filing fees, attorney's fees, and even compensation of the personal administrator themselves. So these expenses are considered necessary for the estate to be properly administered, and without them, the probate process most likely could not be completed. So Arkansas law does place a high priority on these next debts or taxes, and they could be legitimate. So these can include federal income taxes, state taxes, and loans or bills. The key here is that the administrator must pay only those valid debts. If the deceased had a credit card that must be settled, there are unpaid state income taxes, those must be handled as well. Taxes are a serious matter. The IRS and Department of Arkansas Finance Administration have strict rights to collect, and the administrator must make sure that these obligations are not overlooked. Secured creditors are in a special position as well. Now, these creditors hold a legal interest in property, such as a mortgage lender with a lien on a house or a bank with a lien on a car. If these claims are not addressed, the creditor can repossess or foreclose on the secured asset, and that could deprive the estate of valuable property that may otherwise be distributed to the heirs. In short, these categories, funeral expenses, administrative, debts and taxes, and secured claims, form the core list of obligations that must be handled. Let us here at Big Rock Legacy Law Group assist you with the probate process. Click the link below and schedule a call so we can get started. Now let's look at bills that probably shouldn't be paid or don't necessarily have to be paid, but at least we need to have some careful consideration of them. Unverified claims. Personal administrators should not pay any claim that has not been formally verified. Arkansas law requires creditors to file a claim in the probate court within a certain time frame. If someone simply mails a bill or calls demanding payment, the administrator should politely decline until the claim is properly submitted and verified. Claims beyond the statutory limit. Arkansas law limits the time and amount creditors can claim. If a claim is filed too late or it exceeds statutory limits, the administrator should not pay it without any court approval. Disputed claims. If there is a dispute about whether a debt is valid, for instance, a relative insists that the deceased promised to repay a personal loan, but there is no written evidence, the administrator should not pay it until a court resolves the dispute. By resisting the urge to just pay anything, the administrator protects the estate from improper depletion of assets and ensures compliance with probate law, not to mention giving the heirs the assets that they're rightfully due. Now, all of these rules are grounded in Arkansas law, which provide the legal framework for the estate administration. The priority of claims is clearly outlined. Funeral and administrative expenses come first, followed by debts, taxes, and secured creditors. These statutes exist to protect both the creditors and the heirs. Creditors get a fair chance to recover what's owed, but heirs also have the protection from improper or premature payments. It's important for personal administrators to consult with an attorney and seek legal guidance so that they are familiar with the Arkansas probate process. Probate is not just a do-it-yourself project. One mistake can unravel months and months of work. So, of course, not every estate is straightforward. Let me highlight a couple of special circumstances. Insolvent estates. Sometimes an estate simply doesn't have enough assets to cover all the obligation. In these cases, Arkansas law provides for a clear order of priority. Some creditors will just go unpaid, and that's legally acceptable. It's essential in these cases to follow the priority rules strictly. The administrator cannot pick favorites. Family pressure. This is another common challenge that family members pressure the administrator to pay certain bills or distribute assets early. The administrator has to resist this pressure until all obligations are verified and prioritized. Personal liability of administrators, they have to pay wrong bills or distribute assets too early, become personally liable. This is not just about the estate. It can affect the personal administrator's own financial well-being. The role of a personal administrator in Arkansas carries great responsibility, particularly when it comes to paying bills during the probate process. The key principles to remember are: number one, pay bills in the correct legal order: funeral, administrative, debts, taxes, secured claims. Number two, do not pay unverified or disputed or time-barred claims. Always consult the Arkansas Probate Code and seek legal counsel if you're uncertain. By following these steps, a personal administrator not only fulfills their legal duty, but also honors the deceased's memory, protects the heirs, and ensures that the estate is settled fairly and lawfully. Make sure you subscribe to our channel to learn more about how we help our clients every day here at Big Rock Legacy Law Group.